Greetings, everybody. My name is Victor. I'm doing a topic 5, the ASIC advice on providing digital financial product advice against the background of the general law. So, in response to a growing number of digital financial products and their transactions, ASIC has released a number of regulatory guides, consultation papers, reports, and information sheets to facilitate a transition to a better digital advice market. The regulatory guides, as part of AFS licensing regime, emphasizes the procedural distinction between general and personal service and the exemptions, in which different requirements criteria are stipulated under regulatory um, guides 36 and 244. However, the fact that giving factual information is deemed to be exempt from AFS licensing procedures requires a more thorough examination as to how far the scope of exemption should be applied. And there's been a call for more diversification in response to this expanding industry as well. It is also noteworthy to consider the different thresholds for natural persons and digital advice licensees, where natural persons are subject to a high threshold under RG, regulatory guides 146, whereas the contrast to the flexible arrangements under 105 for the digital advice context. The obligation under Section 912A of the Corporations Act will not arise for an AFS licensee if he or she is subject to APRA, which is the Prudential Regulation Authority, unless otherwise the obligation will be subject to having adequate resources, risk management systems, and compensation arrangements. There is also a lack of clarity relating to the involvement of a person in a digital advice process, where the guidance does not cover situations where a human intervention occurs and who this can be done by. So, the contrary to the self-mentioned human advisors that can facilitate the scope of their advice through conversations with their clients, digital advice may not involve any human interaction. So, the setting out the actual scope may occur through choices or information presented in the beginning as a form of a questionnaire, possibly online questionnaire. But this could be onerous, as a very clear communications needs to be made between the parties. In terms of the client's needs in the form of the best interest test, there are challenges, however, regarding how this may meet the best interest duty as per Section 961B of the Corporations Act. Clients should be informed that a number of factors under Part 7.7a of the Corporations Act, as well as the regulatory guides 175 and 244, and the law is technology neutral, making the protection the same as the traditional advice. However, due to the as mentioned, no person interpretation of the digital advice provider, this may be difficult to render the implications of the licensee's conduct and advice that will result in the client being a better position under 761B of the Corporations Act. This also, and in terms of the general obligation, the investment outcome or deemed to be somewhat uncertain in this context of the digital advice, and that more regulation is just more of a regulation oriented, and which means it may not be suited for industry, whereas it should be actually focused on the providers. In terms of the organizational competence obligation, although it states there's got to be at least one responsible manager, we are of the view that there's got to be all responsible managers should be registered, and there's got to be the registration requiring them to do so. And the standard of the responsible managers should also be applied to the digital financial advice providers as well, and more frequent monitoring of the algorithms thereafter. Otherwise, if there seems to be less or more relaxed, then it may cause unintended incentives for applicants to seek more of that particular mode. In terms of the transitional arrangements, it was deemed that 6-month transition period was sufficient, but should not be seen applied unless overseen by a responsible manager. It was noted, however, that there were calls for a longer period to be given, considering the complexity of the practice. But there were also calls for even impose even no transition period at all. Changes to algorithms, any monitoring to testing the requirements should be done, same as under the general obligations pursuant to 912 of the Corporations Act, which apply to all financial services licenses, regardless of being digital or human. Independent third-party monitoring and testing of algorithms should also be required in circumstances similar to where the independent third-party reviews of financial advisors are required. In terms of the self-certification, it may serve as an extra regulatory framework that help maintain the compliance. But there was also the suggestion that since there's a potential duty of care imposed on the advisor, that it may also constitute the conflict of interest. Scale advice also is a concept which recognizes that clients can be provided some flexibility in the receipt of financial product advice. So robo-advice, in this context, the client should be actively demonstrating throughout the course of receiving advice that the limits of the advice are understood. So as mentioned previously, that the two parties must be communicating very clearly. And unfortunately, because of the advice gap, that only 20% of the population is aware of the existence, more promotion is required. And in terms of the adequate compensation arrangements, professional indemnity insurance must be adopted, although there's a concern that the digital advice has the ability to scale drastically, and that the potential damages could be a lot higher. So there you have it. So that the digital product advice requires a high level of consideration and decision-making process indeed, relying on the Corporations Act and the regulatory guides that we've considered. Thank you.